sometimes called extreme risk protection orders,
Right.
are mechanisms employed when somebody is alleged to be at high risk of uh, doing some harmful things with a firearm, but they can't be arrested because there's no uh, crime that's been committed. The problem is that most, if not all, of these mechanisms have little to none of the due process protections specified in the U.S. Constitution's Fourth, Fifth, and Sixth Amendments. That is one of the things that we, as a General Assembly, will have to make sure that is not violated. As you mentioned, I have a reputation, which I'm proud of, as being an ardent constitutionalist. So I and a number of my colleagues will be watching stuff like that very close. The governor's previously proposed bill, which he dropped in May before we adjourned our regular session, didn't meet that test. Now, as far as what's going to happen in the future, I can't tell you. Uh, Other than the fact that I did talk to the governor, and he is not planning on running that same bill again, or so he said.
Good.
Now, what may come, I don't know.
Good. And now, and we were just talking before we started, and as far as notice, he doesn't have to give but a day notice. There's not a requirement for 10 days or 2 weeks or to show the legislation ahead of time, correct?
You're absolutely correct. In fact, the legislation cannot be filed until the call is issued. And it can be written, and many of my colleagues, in fact, I am working on some legislation for that. Uh, I'm working on what I call stopgap, which is basically filing legislation that will preempt, I hope, any of the unconstitutional stuff that comes about. But I know a number of my colleagues are working on legislation in preparation for it right now. So while we're working on it, as it were, I think the term is perfecting it, we still can't file it until that call is issued.
So once he opens up the codes, if he opens up a code that has to do with firearms, has to do with our right to keep and bear arms, then he could actually end up with a lot of legislation that goes opposite of the way he's intending to go, correct?
Oh, absolutely. Again, in the call, he specifies what area of the code he's going to open, and he also specifies any limits that are on the special session. That is a situation which is very difficult for him to do because with what we're talking about here, obviously Title 49, which is education, would have to be opened, and probably Title 39, which is criminal, would have to be opened. And so, again, the way he does that, the specific wording he uses, is going to be very difficult for him to be able to limit a great deal what can be filed. I have received information that some of my colleagues across the aisle have already been working on as many as 25 bills that they're anticipating being able to file. Now, whether or not that comes to be is another issue, and I wouldn't pretend to guess.
Right. Now, mental health is Title 33. Has the governor, I know his original bill didn't touch on mental health or touched on it very little, but has he, we keep hearing about mental health, but has he referenced those codes?
As of this point, no. However, one of the topics of concern, of course, is that the Covenant School shooter obviously had some mental issues, which brings up another topic, and that is that the fact that the so-called manifesto and the other information that this person generated has not been released yet. And I, again, along with a number of my colleagues, are going to insist on being able to see at least a major portion of it, if not all of it, before we start drafting legislation. That is a court stymied area right now, in that the shooter's parents signed ownership of the documents and so forth over to the victims of the parents and or victims. The children were victims, their parents and the relatives of those that were shot, and so they're suing in court not to have it released. There is no Tennessee law that gives them that right, so that issue is one the courts are going to have to resolve, which of course means it may drag out. And if we in fact sit in session without that information, I can't predict what's going to happen. it may very well stymie all, or at least most of the legislation that was going to be considered.
Yeah, highly unlikely that manifesto is going to be made available by August 21st. Is there any chance you think that he might change the date?
Well, other than specifying a date to the press, he has not put anything on paper. That date will be put into the call, and that in the call it will have a specific date. Now, that's a start date. There is no end date. The session can last as long as it needs to. The issues that we run into, quite frankly, have to do with money. That is to say, we, the legislature, still have to pass a funding bill to fund that session, and that's going to have a great deal to do with how long it is, because it's not just paying for the legislators to travel there, but also we have to, spin up all the audiovisual support and everything else that goes with it. It is not a necessarily cheap operation.
Now, so that vote will be the first vote as to actually fund it then? Or is that something that's done prior to the actual opening?
That's done at the end, usually. When we see the end in sight, then we have a bill crafted to say, well, this is what it's cost us, and we have to have an appropriation for it.
Okay.
But nonetheless, that appropriation bill has to be passed during the session.
Okay. So, any guesses on what you think will happen in this session, this special session?
Well, I expect a lot of heat and light and dust in the air. Specifically, some press outlets have let it be known that there are organizations both within our state and outside of our state that are planning on demonstrating. Now, it's tough for me to figure out what they're demonstrating about, because until we do something, it's not like we're doing nothing, so they can't complain about that. And until we actually pass a bill, they can't complain about that. So I'm at a loss to understand what they're going to be protesting over. But nonetheless, I fully expect some of the circus atmosphere that existed earlier to be there again.
Have you heard anything about a good plan to make sure that everybody is safe? Is my first question, and there's another part of that I want to ask.
Well, yeah, the answer to your question straightforwardly is yes. I and several of my colleagues have had discussions with the Homeland Security and Department of Safety, and most particularly with the commander of the Tennessee Highway Patrol. They have, for things like this, they have an entire group of their troopers that they have specially trained to provide security for our capital.
Okay. Now, I know that at the demonstrations back in April, there are a lot of people in there that were not even from Tennessee. And it would seem to me that when we're in session, and especially for a special session, that we should be able to keep people that are not from Tennessee at least out of the committee rooms and out of the Capitol when the voting is taking place. I understand we can't keep them from the outside, but can that happen? And do you have any idea? Have you heard anything about that?
Well, there's been some discussion about it. To be honest with you, I don't know exactly what's going to happen. The suggestion, quite frankly, is not to exclude anybody but Tennesseans, but to make it Tennessee first, so that Tennessee citizens are not kept out by people from other places. Now, again, that will be an administrative issue that would be taken care of by the Highway Patrol and other portions of our state staff where they set that up to control it. Even if I knew what that was, I certainly wouldn't pass it out for public information right now.
Obviously, yeah. So we're hoping that we don't have a bunch of people from out of state filling up the place and that the citizens can't get in there. That's the concern of a lot of us. So I guess we'll see here in a few weeks one way or the other.
As a matter of fact, about 3 weeks from today.
Yes. Now, the first day is just all organization, right? I mean, do we have to worry about anything actually happening on that first day other than organizing?
No, we have to do the same thing we do with every session. We have to adopt rules. We have to specify committees. The mechanics of the session have to be established, even though it's going to be very similar to what we have routinely anyway, except the rule book requires us to do it. So there will be a period of time where we're just going through things like establishing the rules, getting committees appointed. And again, the speaker has to do all that work. So I presume he's going to show up at the session having already considered a lot of that stuff and be prepared to do it. But it still takes time.
Right. Okay. Well, like you said, in a few weeks from now, we'll know. I want to talk a little bit about some of the legislation that you sponsored this past session. House Bill 1376, it was the Tennessee Higher Education Freedom of Expression Act. Can you kind of give us a brief description and explain how the bill will be enforced?
Well, actually, this bill 1376 was intended to be an enhancement to the enforcement mechanism that was already there. The original bill, which was passed in last session, was something we call the Divisive Concepts Act, right, which is very similar to the Prohibited Concepts Act. The Prohibited Concepts Act was for K through 12, and the Divisive Concepts was for higher education. And House Bill 1376 was putting a mechanism in place to allow people who observe violations to submit a complaint and have it investigated. So that was the purpose of this act. It set in motion, if you will, the train of events, rulemaking, and so forth, to create a complaint mechanism and force institutions to investigate it. The bill also provides for posting the investigations on the results of the investigations online. Now, of course, you have to understand that there's something called FERPA, or the Federal Education Protection Act. I've forgotten exactly what the acronym stands for, but the idea is that it has to be sanitized of personal information.
Right.
So when it goes online, it would have all that information taken out of it. Additionally, the act also reinforced some stuff we already had on the books, but it clarified it and restated it concerning the fact that these institutions can't charge security deposits for conservative groups if they don't charge it for everybody. And if they make facilities available to liberal groups, they have to make it available to conservative groups, the same facilities, same kind of venues, etc. So again, we had something like that already established, but this bill refined it and re-emphasized it. So we created a situation where we have taken away, I hope, the ability of some of these liberal university bureaucrats to try to keep conservative speakers off campus. That was all part of this bill.
I think there's some people that don't understand that even here in Tennessee or in the South in general, that our universities are as woke as any of them, as they say. I mean, you can't just assume that because we're here in the Bible Belt that the garbage that we hear about in other states is not happening here. And obviously that's why we ended up with this legislation.
You're exactly right. And now the good news is that not all of our universities are like that, but there's a significant number that are. And that significant number is what this bill was written for.
Now, as far as enforcement, I know that I think there was a council set up to do the investigating.
Yes, each university is required to create an organization to do the investigation, which, by the way, they can multi-purpose another investigation mechanism in place if they want to. It's not requiring them to start from scratch.
And who at the state level is kind of checking the checkers, so to speak?
Well, that comes back to the Tennessee Higher Education Commission.
Okay.
And of course, you mentioned that I chair government operations. Government operations is the watchdog committee. It's the oversight committee. And all of these organizations must come before my committee. And of course, since I've written this legislation, you can bet that I'm going to keep track of it. And when they come before the committee, they'll have to answer some tough questions.
Well, I'm confident that that you do a good job on that. I have no doubt in my mind on that. House Bill 1377, that's prohibited concepts, and you said that applied to K through 12. And I know that I guess there's a lawsuit, so there's certain things you can't talk about in reference to this, but whatever you can tell us about this and not get yourself in trouble, I'd certainly like to hear.
Well, the lawsuit is not actually about 1377 because, like the previous bill we discussed, the prohibited concepts law went into effect in 2022, the previous session. This bill was putting more teeth into the enforcement mechanism. The previous bill's enforcement mechanism was the Department of Education, specifically the Commissioner of Education, withholding funds from school systems that were allowing these prohibited concepts to be taught as or advocated for, I guess is a better way to say that. And this bill expanded that mostly as to who could submit a complaint, because the rules that were put out by the Department of Education, in my opinion, unfortunately, limited the people who could complain to the school employees, faculties, teachers, and parents. And there's nothing wrong with that. That was one of my intents, but I also intended for any taxpayer in the district, the school district, to be able to file a complaint on it, because quite frankly, this goes back to the days of the American Revolution when we were talking about taxation without representation. Regrettably, this bill failed by one vote in the Senate, and that issue is something I'm not happy with. Parliamentary wise, we could bring that bill back, and I say we, it doesn't need to be brought back in the House. The Senate could bring it back. They could move for something parliamentary known as a reconsideration motion. Now, whether or not they will, I don't know. I have talked to the people who voted against it, and quite frankly, their attitude is, well, we've got more on our plate than we can handle. We don't need to be going back. So I'm not really sanguine about them being able to do that.
So the fact that there's a lawsuit for the original law before 1377, that wouldn't necessarily stop them from bringing this back if they wanted to?
It wouldn't stop them, but it would certainly discourage them.
Right.
The legislature is reluctant, and rightly so, because we've got three separate branches of government and they're co-equal. So if something is going through the judicial branch in the legislative side of the House, we're reluctant to stir that pot until it's settled. So I doubt that it'll come back until that lawsuit's complete.
Okay. House Bill 1378, the Youth Health Protection Act, and that one did not pass. But if you could just tell us a little bit about it, and if you think you can, if you intend to bring it back next session.
Well, actually, that bill was filed before, or let me rephrase that. It was drafted before House Bill 1, Senate Bill 1. And it had the same purpose as those two. So I held it in reserve in case something happened to House Bill 1, Senate Bill 1. They passed. And in fact, they passed with an overwhelming majority. Therefore, this bill is not needed. And so there's really nothing to do with it. I'm going to leave it sitting there. I probably will. I like to have my name associated with that, although I was a co-sponsor on the other one too. But as far as it being called into a vote or something like that, probably not.
Okay, but the health protection, the description of it, you said it was the same as Senate Bill,
Yeah.
House Bill, and that had to do with performing surgeries on minors for
hormone therapies, surgeries, etc. The idea being that in Tennessee we don't allow a minor to get a tattoo. They have to be 18 years old to get a tattoo. The theory behind that is it's a permanent marking.
Right.
So why would we allow a minor that we don't allow to get a tattoo till they're 18 to have something potentially more disastrous and more permanent done to them?
It's a good question. I don't understand why I can't understand how a doctor doesn't automatically lose their license for doing something like that anyway. It kind of blows my mind that we even have to make that law up.
Well, in the laws that exist now, their license can be revoked. They are subject to going before the Board of Medical Examiners and having to explain themselves to that board. Otherwise, they could lose their license.
Right. It's a shame to think some of the things we actually need legislation for in this day and age.
Well, you're absolutely right. And the other piece of that puzzle, of course, is that this is a relatively recent phenomena, and I'm willing to bet that it's a passing fad among young people. It's like the nose rings and the belly button rings and stuff like that. At some point, that fashion will pass. Unfortunately, with the belly button rings and the nose rings, etc., you can take those out and they heal up. It's not a problem. But when someone has had their uh, body parts removed and or has become permanently sterile because of hormone treatments, you can't undo that. That's not a nose ring option.
Right, right. Well, that's a fad that can't pass away fast enough, in my opinion.
We are in agreement there.
And this is kind of related, although it has to do more with vaccines, I believe. But the House Bill 1380, the Mature Minor Clarification Act. If you could talk a little bit about that.
Well, that bill actually has more to it than it sounds like. You are correct that it was driven originally by vaccinations because we had something in this state was created by a court case called the Mature Minor Doctrine. And that doctrine basically said that any child over the age of 14 could get a vaccination or some of the medical treatments without their parents' consent or even knowledge. Now, it was mostly vaccinations. However, the way that doctrine was being interpreted, it was other things too. So the bill was written to say that a minor, that is to say anybody under the age of 18, can't just get a vaccination willy-nilly. They have to have a parent or guardian approve it. In other words, it's got to be documented in the record. What that does, besides clearing up the vaccination issue, though, is in the findings that we put in the bill, we specifically refuted that court doctrine as it applies to medical issues for minors. So it's a stake in the ground beyond vaccinations. Now, again, the mature minor doctrine as a court-related issue still exists, but it will only be inside the confines of a courtroom. And that was one of the purposes behind this bill, was to make sure that the General Assembly was on record saying that, sorry, a 14-year-old, we won't allow them to get a tattoo. We're not going to allow them to do anything else that they're not fully cooperating with their parents with. And that, again, there's been some blowback on that. I'll be honest with you. In many cases, kids getting school vaccines are taken by grandparents or aunts and uncles, and they can't sign that permission slip. It has to be a parent or guardian. And so, I've gotten some rather strongly worded communications from people who felt that they were being inconvenienced by that. But my answer to that is, I'm sorry you're inconvenienced. But if you know the law now, all you've got to do is get the parent to sign a piece of paper before you go.
Right.
And it's a done deal.
Well, that's another one of those that we needed to get past, and I'm glad that one is on the books now. Switching over here a little bit, House Bill 1385, intent to go armed, and this is a gun bill. And I know there were several. I think there was other legislation that also dealt with this. But it's kind of strange in Tennessee. Our Constitution says we have a right to keep and bear arms. It does allow the legislature to limit the wearing of arms, supposedly with a view towards reducing crime. But if this whole intent to go armed thing, the governor passed what he called constitutional carry, which is really permitless carry. But we still have on the books, a law that says it's the intent to go armed with a gun or with a club is illegal. So there just seems to be a lot of contradiction there.
Well, again, you're absolutely right, in my opinion. And I explored completely eliminating that phrase, but that takes a constitutional amendment. So instead, I put into the law the definition that the intent to go armed is for the purposes of it being a criminal offense, is the unlawful carrying of a weapon with the premeditated purpose of committing a crime. In other words, if you happen to be by definition, if you're wearing a firearm, you have the intent to be armed. It's a conscious act to put it on.
Right.
So the idea behind it, the bill that I put forward, was to say, okay, if you are not strapping that weapon on or carrying it, if it's a club, whatever, uh, with the intended purpose of going forward and committing a crime premeditated, in other words, it's not by accident that you just happen to have it on you, uh, then it's a no harm, no foul situation. Now, unfortunately, that piece of legislation failed by one vote in the Senate. Well, I take that back, it's more than one vote, but it failed in the Senate. And again, I think there was some misunderstanding about that, but there was some active lobbying by the Department of Safety against it. And that's another issue that I have a problem with is the executive departments basically sending their personnel over to become lobbyists. They stand in front of a committee and testify that they have a philosophical opposition. Well, I'm sorry if they have a philosophical opposition, but I don't care. Because in my mind, the legislature creates the laws, not the executive branch. If we want their opinion, we ask for it. If we don't need it. And well, I'll let that rest there.
Oh no, I agree, and that's been brought up by other people on this that have come on the show that the Department of Safety regularly they've done it for years, as well as, and although it's not an official state agency, the Sheriff's Association, which is supposed to be, helping take care of employees, and they're not a lobbyist. They're supposed to be a charity, but they lobby against gun legislation all the time. And like you said, Department of Safety lobbies against our rights, and that is pretty frustrating that's allowed to happen. It seems to me, I don't know, we almost need a law. Do we need a law that says the executive branch cannot use employees to lobby against legislation?
Well, you run into some problems there, to be honest, because we need to have the opinions from the executive branch on feasibility, on cost, on personnel impacts, and stuff like that. They are the on the ground experts, if you will, as far as how it affects their organizations. But we don't need their inputs on the philosophical implications of something or other. That's for the representatives of the people, those people who stood in front of the voters and said, "These are my positions. Vote for me if you like them, and if you don't, vote for the other person." If you get into office, that means your constituents have said, we support your positions. And the Department of Safety has no business, since they're unelected, trying to influence that otherwise.
Right. Now, you said that lost by a few votes in the Senate. That seems to be a reoccurring theme. There's a lot of good legislation that's sponsored in the House, and it just seems like the Senate kills so many of the good bills that we get through the House up there, or that at least are moving in the House.
Well, there's some merit to that argument, I'll be honest with you. The flip side of the coin, though, is we are a deliberative branch in two separate portions of it. So even though I disagree with the Senate on many cases, I am willing to support their independence. And frequently, we will have a disagreement on a bill, and they will pass a different version from us, and we will have a conference committee and actually come out with a better piece of legislation. That happens. However, when they outright kill a bill and you don't have a chance to say, well, what don't you like about it? What can we change? What do you want added that we can put in there? There's no negotiation. When it dies in their committee, you don't get that opportunity.
Right. And so for instance, we had the elections in 22, the session in 23. So if there was a bill that went through committee, now if it just didn't get a second in the committee, it can still be brought back in the second half of the session. But if it was voted down, then it's dead for that session, correct?
No, not exactly. Again, a committee can vote to reconsider their actions.
Okay.
So even if they voted it down. Now, the only place that doesn't happen is when it's not just voted down, but referred to in the Senate. They call it the committee of no return. They have a subcommittee they send bills to, and that pretty well kills it. In the House, we can actually vote on the floor to kill a bill forever for that session. Doesn't happen in committee, so.
Okay, okay. But just in the House, you can bring back something as well that may have
Yeah, well,
lost.
even in the Senate, they can bring it back.
Okay,
Uh, uh, that said, though, once it's been voted down, it's a really steep uphill climb to reconsider, because the person or people, I should say, who voted against it presumably had read it, had a reason. So you have to convince them that their reason was flawed, and then you have to convince other people that were there that are going, well, gee, I don't know about that now. After I've heard that explanation, I don't know that I like it either. So it's an uphill climb.
right, right. Now, the last bill that I got up here is House Bill 1386. It's the Common Law Marriage Recording Act. And if you could give a brief description of it. Now, I know brief is a relative term because it's a fairly long bill. And especially if you focus a little bit on the Ninth Amendment is mentioned repeatedly under the findings section. So if you could tell us a little bit about this and why it's important.
Well, let's start with the fact that my grandparents were married without the requirement to have a marriage license. Interestingly enough, I have a marriage certificate that was drawn up by one of the local artists in the community there that functioned as that. But the idea of a marriage license is a fairly recent concept. Nearly every marriage, going all the way back to Adam and Eve, if you will, was what we call a common law marriage. And the states picked up recording marriages from churches. The marriages were recorded in churches. The state picked that up primarily because of the difficulties in inheritance law.
Oh, okay.
And the intricacies of inheritance law were bad enough way back in the biblical days, and they've gotten progressively worse ever since. So from that standpoint, we have a requirement to have a document that is available to the public and relatively assured of being correct, so that we have no problems with that. And of course, since the late 60s, we've also had no-fault divorce, which has complicated issues with marriage and marriage licenses. So it's become an even more difficult situation. Now, having said that, the state requiring a marriage license is where I have some problem, because, like I said, the common law predates our Constitution. In fact, it predates Western civilization. Common law for marriage has been around, well, since the biblical times and before. So the idea that we have to say you have to have a license to be married is a violation of that. And the Ninth Amendment that you mentioned in our Constitution was designed to ensure that, if you will, it was the stake in the ground that said the Bill of Rights says some things, but that's not all the rights that we have.
Right.
We as citizens have a whole lot of others, and just because we've enumerated those in the Bill of Rights doesn't mean we're limiting it to that. And so this is based upon common law, which is protected by, like I said, the Ninth Amendment. And of course, to some degree, the 10th Amendment comes into play there too.
Right.
There are states that recognize common law marriage, and this bill would have just put Tennessee in that other group that recognizes it and allows. By the way, this is one of the motivations for me carrying the bill. The previous governor changed the marriage certificate from husband and wife to some other language that I won't go into. Let's just say it's woke, and I don't like it. But this gives the opportunity for people to get married and not have to put that down. The certificate that was specified is something called a record of marital contract in common law. And so they can say that we are husband and wife and have it recorded as such. Now, I'm going to be perfectly honest with you. I'm not sure. This bill, by the way, is still waiting to run it. Senator Bowling is my Senate sponsor, and she's got some plans in the Senate. I was sitting on it in the House until she told me that she was ready to roll with it in the Senate. So from that standpoint, I am kind of waiting to see what's going to happen there before I put it on notice.
Do you know when Tennessee first started requiring marriage licenses?
I can't tell you for sure, but I think it was back in the teens or 20s of the last century. It might have been before that. Uh, there may have been a provision where marriage licenses were in existence, but they weren't necessarily required. Like I said, my grandparents, my grandmother is from Mountain City, Tennessee, and they were married without a marriage license requirement. So the idea of a requirement for marriage license is not that old. Now, whether or not marriage license is recorded before then is a different issue. Today, we consider that a vital statistic that the state is required to maintain for a lot of different reasons, not the least of which, as I've mentioned, is divorce law and inheritance law. But there are other reasons that they maintain it. And in fact, the federal government, as usual, gets involved with the act of passing out money for certain things. And in order to qualify for that money, you have to be able to document that you've got it done, et cetera. That said, the idea that I have, quite frankly, is that fine, if you want to do it, go for it. But the state shouldn't say you have to do it. And I will say also that I have been an officiant. That is, I have actually married people. And so from that perspective, I have a little more than just a passing interest in it as well.
Right. Now, you mentioned that Haslam changed the document. Governor Haslam at the time changed the document. That was after the Obergefell decision that basically attempted to mandate gay marriage on the whole country, which is something that they really did not, the court doesn't have the authority to do that. I was really disgusted that our governor, within the first hour of that opinion being announced, folded and directed his attorney general and whoever else to comply and change everything. And I was really disappointed that there wasn't more pushback from the legislature. I would have thought in Tennessee, especially since we had in our Tennessee Constitution that marriage is just between a man and a woman. I really was hoping for more pushback.
Well, let me suggest to you that the fight is not yet over. You mentioned the Attorney General, and quite frankly, the governor directs the Attorney General, yes, but the Attorney General is actually a member of the judicial branch,
right,
not the executive branch. And so the Attorney General doesn't have to do whatever the governor wants. He can pretty well do what he wants. And the Attorney General at the time, I think, sent a strong message that he was not willing to take on that fight. And so the governor, having the philosophy, I suppose, that the buck stops at the top and I'm at the top, therefore we're going to say that I did it. Whether that's true or not, it's a different issue. But you are correct. It's in our state constitution that, and by the way, I dare say a number of your viewers have voted for. I voted for that constitutional amendment way back, I think, in 2006. It's 2006. Been a while. Yeah. So from that standpoint, it's, and by the way, it's still in our Constitution.
Yes, yes. And what we're doing, issuing anything other than, marrying anything other than a man and a woman is unconstitutional as well as immoral, even though our state's doing it and has sanctioned it now since 2015.
Well, again, the only bit of advice I'll pass along to you there is to remember that the wheels of government turn slowly, and especially in the legislature. And there's also a great deal of back channel communication and negotiation that goes on to get support necessary. I have a constituent who is divorced and has been on me, like you wouldn't believe, to get divorce laws made more just, in his opinion. And frankly, I don't disagree with the man.
Right.
I have to tell him up front that when I go around and talk to my colleagues, I have to have 50 votes in the House and 17 votes in the Senate. And when I count noses, if I don't get that number, then it's not worth my time to push it. Now, in some cases, I will push a bill anyway to make a statement if it's a particular issue that I think needs to be on the record. but divorce law is not one of those things I'm necessarily think needs to be on the record. So
Right.
I'm uh, some of the bills that you've mentioned. Yeah, I'll push those for all they're worth,
Yeah.
and then some. As my colleagues will tell me, maybe more than they're worth.
It seems to me too that ever since not just Tennessee, but the whole country caved on that issue, okay, caved on the issue of gay. That's when all this other sick stuff just accelerated. All the transgender and gender identity garbage, that just seemed to me, I mean, it was already there, but it just seems to me it went into overdrive after that.
Well, I certainly can't disagree with your analysis. That said, though, as a former military officer, I view this as a battle, and the battle's still raging. Uh, General John Pershing, who was the highest-ranking American commander in World War I, said, "Battles are won by tactics, but wars are won with logistics." And translating that into the political environment, what that to me means is we can't necessarily win this war all at once.
Right.
We go after it and we pass enough bills around the edge of it. Finally, we get enough built up that we can push it and win it. And unfortunately, for people who don't follow politics or not eat up with it like some, that doesn't make a lot of sense. Their attitude is, well, it's wrong, fix it. And frankly, I would like to say, yes, let's do it. But as I said, things don't happen quickly. In addition to that, you've got a very strong, if that's the right word, let's just say well-financed
Right.
group that stands opposed. And that well-financed group that stands opposed to you can impede you more than you realize. For those people that are watching this and don't understand, the best principled politician, I don't care which side you're on, you still got to get money to buy newspaper ads and mailers and rent halls for town hall meetings. You pay for radio ads and TV ads. And I'll tell you right up front, it ain't cheap. And so when you have a well-financed opponent, you've got to get yourself financed. And that means that sometimes you have to agree to not push things that you otherwise would. And I'm not saying stand against it. That's not what I'm saying. I don't do that.
Right.
But like the guy I was talking about with the divorce laws, I've got some more important fish to me out there right now in terms of principles.
Right.
So I'll chase those first, the limited time that I have. And I think a lot of my colleagues are in the same boat, if you will. The necessities of getting it done require a compromise here and there, and sometimes the compromises are a little hard to swallow. But the half a loaf is better than none.
Right. Well, and I'll say this, since I've kind of followed Tennessee politics now for several years, is the left is better organized than we are. They're better funded, and they're more involved. I think one of the problems with our side is they pay attention at election time, but then the reason that we elected those people to begin with was to do the right thing during session. Well, a lot of these people, you can't get them to make a phone call during session, forget having to make a trip up there. And that is hard to do. I work too. I can't get up there all the time. But we have to be on the right in Tennessee, and probably everywhere, has to be more involved during session, not just during campaigns. So we've got to step up. I think most people in our state are conservative, do think like we do, but not enough of them get involved. And so that makes it hard for people like you who are trying to do the right thing.
Well, and again, I have to say truthfully that you can tell from the color of my hair that I've been around the block a few times. And so my identity is not tied to the title that I have, representative or chairman. So if I don't get reelected because of something I did, if I thought I did the right thing, well, so be it. However, some of my colleagues get that identity, it becomes a personal thing to them, and they think, my God, I have to get reelected. It's me as opposed to what I do. And so they may be more willing to make some compromises that the rest of us might not. And therein is part of the problem, because politics is the art of compromise, but you got to make the right ones at the right time.
Right, right. You mentioned the 10th Amendment a little earlier, and I know you're a big supporter of the 10th Amendment, and of course I had spoke to you about our organization, Tennessee Citizens for State Sovereignty, and I know that you agree with trying to get Bud Holsey's legislation on nullification or some version of it through the legislature this upcoming session. So just a couple of questions in terms of nullification. Do you see any other feasible way to restore our republic without nullification?
Well, again, nullification and its twin sister, interposition, which are two doctrines that are essentially very much the same, have some issues that are difficult to resolve. The idea behind nullification or interposition is that if the federal government creates a law, or one could say even now an administrative rule, that the state considers unconstitutional under the doctrine of nullification or interposition, the state will just say that doesn't apply within the borders of this state. That sounds really good, except that we have Article 4, Paragraph 2 of the U.S. Constitution, which is commonly called the Supremacy Clause, that we have to deal with. And that Supremacy Clause says that a federal law that is considered constitutional trumps the state. From that standpoint, I see you have it on the screen there.
Right.
From that standpoint, declaring something to be nullified, or the state taking the doctrine of interposition, means that there's a dispute. And under our system, disputes are settled in the judicial branch. So there's some issues there. Now, I will give you one instance where nullification is being used successfully, and even though I don't personally like it, that's the marijuana stuff.
Right.
There's a number of states that have declared marijuana to be legal, even though under federal law it is illegal. So they basically said, we're nullifying it. Now, under the Supremacy Clause, the state really is not supposed to be able to do that. But the courts have said the feds cannot force the states to enforce federal law. The feds have to do it themselves.
Right.
So in theory, you take a state like, I'll pick one, Colorado,
Yeah.
or California, that has legalized marijuana. The feds could come in on their own. They could bring the FBI and the marshals and whoever else they want to and enforce that law. California doesn't have to help them enforce it. But California can't stop them from enforcing it either. So in effect, they've nullified federal law because the feds have refused to enforce it. Now, again, we can quarrel over the doctrine of whether or not the president and the attorney general are carrying out their oaths to faithfully enforce the laws of the country. In my opinion, there's a problem, but then they've got problems all over the place up there right now.
Right. But now, back to the Supremacy Clause for a second, though. It says the Constitution and the laws made in pursuance thereof. So not every federal law is automatically constitutional.
You're absolutely right.
And I understand that we primarily use the courts, but if it's something blatant, let's look, for instance, to the marriage issue. 2 years prior, the Supreme Court had said marriage was a state issue. I think it was Winslow or Widner or something like that. That was a case just 2 years prior to the Obergefell case. And then 2 years later, all of a sudden, it's not just a state issue. It would seem to me that the 9th and 10th Amendments, to mean anything, just as the federal government has enumerated powers that it's allowed to, that it's expected to make law to enforce those federal powers, it would seem to me that we are supreme in the powers that we retain. And so it seems a little strange that on every question, we would have to take it to the federal government to determine the limits of federal power. It seems to me on some things we would just say, no, we're not going to do that.
Well, again, we can do that. The states can say, we're not going to enforce federal law, and we are not required to. The courts have said the states do not have to enforce federal law. but we can't stop the federal government from enforcing it if they choose. So again, like the marijuana example is a good case in point. The states are not enforcing the federal laws on the drug issue. If they were, they'd have to say that marijuana is not allowed, and we will put people in jail for doing it.
Right.
It's a Schedule I drug. However, the states are not doing it, and the feds can't make them do it, and the feds are not enforcing it. So there's an example of nullification working in action. The issue that you come against, though, is if the feds decide to enforce it, the states can't stop them. And so, to your point on the Obergefell decision, the mechanism that they would use to enforce that, I suspect, would be just like the Department of Education tries to do. The feds would say, well, we can send in, the troops, which, by the way, was done back in the civil rights issue, or we can just say, we're not going to give you all the money we promised you. And there are states that would, frankly, go bankrupt without federal money. We won't call any names, but Illinois comes to mind. Without the federal funds that they get, they'd be bankrupt.
Right.
And there are several other states like that. I just mentioned that one by way of example. So some of these states are put in a very difficult bind. The doctrine of interposition, which is related to nullification, nullification says that a state can say this is null and void. Interposition basically relies on multiple states saying that. And again, that has been the way that the marijuana has kind of gone. The states have interposed themselves rather than nullified.
Right.
And again, they're getting away with it.
Yeah. Well,
I doubt very seriously that they would get away with it with some of these other issues.
Yeah, and they may not, because I think the federal government, the people running it now, are all for legalizing marijuana. So I think that's part of it.
Well, if Congress changes the law, again, this is not a constitutional issue.
Right.
Drugs are not mentioned anywhere in the Constitution, so it's a federal law issue. If Congress changes the law and says tomorrow that marijuana or pick a drug, doesn't matter, is no longer a Schedule I drug, then instantly the situation changes.
Right. Right. But I think I think the nullification, especially in this day and age with the federal government that just blatantly violates the law, the Constitution on a daily basis. Everything from the immigration issue to pick a topic. It seems to me like states are going to have to be a little more aggressive, and I don't mean taking military action. I'm just saying a little more aggressive on nullification / interposition. I don't see us voting ourselves out of this situation.
Well, in Congress, you're probably right. And I will point out to you something that I'm quite proud of my colleagues for doing, and that is the two speakers, McNally and Sexton, are sponsoring a bill to create a commission to look at giving up, as in doing without, all of the federal money for education.
Good.
What that does is it gives us an incredibly strong hand then to say, if the Department of Education comes up with some of their falderall, we ain't doing it. And you can go pound sand, because you're not going to send troops down to make us do it. And we don't want your money anymore. Yeah. There are some states, though, and again, I won't call any. Let's see. I'm going to be very tactful. Let's put it that way. Tennessee has 7 border states, as you well know.
Right.
And so some of our border states would not be able fiscally, that is the money,
right,
to do that, or perhaps political will. We're in a poker game with this situation, to be honest with you, and it's going to boil down to whether or not the feds think we're bluffing. The will in the legislature, and I sit on both of the education committees in the House, as well as on the joint education committee that's part of GovOps. I don't think it's a bluff.
I hope it's not, because we need to do that, and education is the perfect place to start. Probably one of the most important places to start, considering all the garbage that's being pushed.
Absolutely, and quite frankly, you mentioned the enumerated powers. That's one of the things that's definitely not an enumerated power, and in my opinion, has no business being part of the federal government.
Absolutely.
Again, the amendment that gave the federal government the power to levy income tax essentially gave them a lot more power by virtue of the dollar
Right.
than they were ever intended to have by our founders.
Absolutely. Well, hey, I really appreciate you being with us tonight. Hope to have you back on sometime, and can't thank you enough.
Well, I'm glad to do it. Thanks, Dave, and to all your viewers. I encourage them, as you did in the beginning, to stay involved in your government. I've been married for over 50 years, and I don't agree with my wife on everything, even that long. I'll guarantee I don't agree with all my constituents, and they don't agree with me on everything. But just like with my wife, I agree with her on enough things that we definitely stay married and love each other.
Right.
So I would hope that if they get involved with government and find that they disagree with representatives on some things, that there's enough things that they do agree on, that they'll hang with them and support them.
Yeah. If not, they'll help find a replacement.
Exactly.
Well, thank you again. I really appreciate you being with us today.
Take care.
And thank everybody for joining us. If you enjoyed the show, please hit the like button and subscribe. Join us next week when our guest will be Representative Rusty Grills, on one of the solid young gun conservatives of the General Assembly. Thank you. See you next week.